and or to grant bond or bail is provided for under Article 49(1)(h) of the Constitution. The article stipulates as follows. An arrested person has a right to be released on bond or bail on reasonable conditions pending a charge or trial unless there are compelling reasons not to be released. The essence of this court in reproducing this article is to consider what is contemplated by the phrase reasonable conditions. Under this article, which upholds the accused's right to bail, the court is empowered to impose conditions so long as it considers them necessary to ensure that the interests of justice are not compromised. If, therefore, a constitutional office holder is charged with a criminal offense and the court is of the view that a condition that limits access to his office should be imposed, would it be a violation of the Constitution? In my view, since the Constitution has given the court the power to impose conditions on granting of bail, it would not be a violation of the law unless, of course, it can be shown that in so doing, the court is unreasonable or has taken into account unreasonable considerations. If limiting or restricting a constitutional office holder from going back to the office can be termed as a constructive removal from office, then it would mean that the court cannot apply Article 49(1)(h) fully in cases of constitutional office holders facing charges before it, even when it considers that circumstances warrant such an imposition. I don't think Article 49(1)(h) intended that certain category of accused persons get preferential treatment when considering the conditions that the court can impose in the interest of justice. I further do not agree that limiting the governor's access to office is an affront to the Constitution, principle of presumption of innocence, for if it were to be the case, then denying an accused bail or bond would be tantamount to condemning them to finding them guilty. Yet, there are many people in remand who have been denied bond and they continue attending court for the trial of their cases. Imposing conditions that guarantee integrity and credibility of the trial cannot be an illegality. It must be underscored that this has always been the position of this court, and even in the Zwazuri case, that is what this court had delicately opined. The submission made by Professor Onjenda that even where the court declares a law to be invalid, it does not become so unless repealed by Parliament is, in my view, misleading. The learned professor referred the court to petition number 56 of 2016, James Gasheru Karaoke and 19 others versus the county government of Mombasa to buttress that position. However, my reading of the same authority revealed that what was an issue in that case was not an issue of a section of law or law that was unconstitutional. Rather, what was in issue in that authority were two statutes which were contradictory to each other, and the court was being invited to order the repeal of one while maintaining the other. This is what the court said it could not do. It could not be invited to do, and held as follows. There is nowhere in the Constitution or in the Act where the High Court is empowered to repeal or order the repeal of statutes that are considered illegal or contradictory. On the contrary, the High Court has expressed power to interpret the Constitution, and in so doing can declare any law that is inconsistent with the Constitution void to the extent of the inconsistency, and Article 2(4) of the Constitution. As for the other cases relied on by Professor Tom Onjenda on issues of integrity, I found them to be more general in their approach as opposed to the more specific decision of Justice Mumbi Ngugi, which addresses the relevant provisions of the Act on which charges against the accused persons are founded. As for the submission that the governor's absence will orchestrate a lacuna, that too is addressed by Justice Ngugi, where she considered Section 32, subsection 2 of the County Government Act, in which she observes that the governor, if the governor is unable to act, his functions can be performed by the deputy governor. Barring the first accused from going back to the office, therefore, does not violate the Constitution or amount to removal. It is intended to ensure the integrity and credibility of the trial and to ensure that public interest is safeguarded. Indeed, the judge in anti-corruption case number 25 of 2019 captured this concern more aptly when she remarked, and I quote, He is charged with basically enriching himself at the expense of the people who elected him and who he is expected to serve. Would it serve the public interest for him to go back to the office and preside over finances of the county that he has been charged with embezzling from? What message does this send to the citizen of their leader when their leader, if their leaders are charged with serious corruption offenses and are in office the following day overseeing the affairs of the institution? End of quote.